Good morning. Are you Lamone Yman Jr.?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
You will, Your Honor.
Let me get on. I should have another one coming also.
Yes, ma'am.
Okay. Mr. Yeoman, in cause number 19-32846, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation November 12th of 2019 for the offense of aggravated assault with a deadly weapon, and that was a 10-year deferred probation. Is that correct?
Yes, ma'am.
And then in cause number 23, DCCR 1556, I have a first amended motion to revoke your community supervision. Shows that you were placed on probation July 17th of 2024 for the state jail felony offense of burglary of a building. And that was a 2-year term in state jail prison that was probated for 5 years. Is that correct?
Yes, ma'am.
Each of these cases allege that you violated your probation. Count 1 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and specifically avoid association with any person previously convicted of a crime, or be present at a location where a criminal act is committed, in that you were supplying other residents of the Cheyenne Center with K2 synthetic marijuana. And is that true or not true?
It's true.
Okay. Count 2 in each case alleges that you failed to report to the probation office as directed April 2nd and April 3rd of 2025. And is that true or not true?
True.
Count 3 in both cases allege that you possessed a drug, K2, on or about March 30th of 2025 in violation of your order. Is that true or not true?
Not true.
Not true? Okay. Count 4 alleges that you failed to successfully complete the safety program as directed. Is that true or not true?
True.
Count 5 in each case alleges that you committed the new offense of possession of a controlled substance, penalty group 1, August 8th of 2025. And is that true or not true?
True.
Count 6 in each case alleges that you committed the offense of possession of a firearm by a felon, August 8th of 2025. And is that true or not true?
Not true.
Count 7 in each case alleges that you failed to report to the probation department April 11th, April 21st, April 30th, and May 9th, June 6th, and July 7th of 2025. And is that true or not true?
Not true.
All right. Did you enter your pleas of true to counts 1, 2, 4, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of your cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand I think y'all did the paperwork backwards.
We did originally, then we corrected it. At least I thought we did.
So,
It is a cap of 8 on 19-32846, and a cap of 2-year state jail on 23 DCCR 1556.
well, it's set, hold on. Anna, can you send me back 23-1556? I just sent it.
that may be the third degree paperwork. I think he may be right.
Yeah. Okay. I think, so 23-1556 is the burglary of a building,
Every state.
but y'all did TDC paperwork. And the other one, yeah. So those have to be right. So
We can read them.
I'm going to delete both of those.
That's fine, Judge.
I'll just hold this. We'll continue the hearing. I'm not going to go back over everything. We'll just go over the paperwork as soon as it comes through. And did y'all do it twice? You
We
said?
did, there was,
I think I got the numbers wrong. We did them.
Okay,
I'm happy to redo them both.
sorry.
That's my fault.
All right, I'm going to delete both of those. All right, y'all just go have a seat in the jury box and we'll get that done. Let me delete that. I was looking and I was like, wait a minute, that's because I thought it was a cap of 2 on the TDC case. I'm like, what? Okay,
Yeah, I forgot there were different levels. Luke caught the mistake. I thought there were different levels.
okay.
Do you want to plead him just now, or do you want to do them when we do the other guy?
Go ahead and get that one done, and that way I don't keep this over here and get confused for too long, and I'll take care of a couple other things. Let's see. Mr. Kimler, you have Sheena Harmon.
yes, sir. Judge, if I can, there's a lot of family members here on the side too.
Yeah, which one?
It's Christopher James.
Okay, I'll take care of it next.
Thank you.
Would y'all put that Christopher James sentencing up here for me to do next, please? Thank you. Ms. Malfino on Colton Armstrong with Mr. Kimler. Is it yours?
This is Harmon. This is
What did
Harmon.
I-
This is Harmon.
Oh, that's why never mind. Just testing everyone. Okay. Gosh, I feel like Monday. All right, are you Sheena Harmon?
Yes, ma'am.
Not Colton Armstrong? Are you sure?
Yes, ma'am.
Okay. And will your client waive the formal reading of the indictment?
So,
Okay, we're going on all of the counts.
whatever
Or
makes
at
it
least-
third.
Okay,
Whatever
got it.
gets us with the judge.
Okay, I got it.
I think we're gonna need all of them to get us to it.
Okay. Ms. Harmon, in clause number 25, DCCR 0649, you're charged with the state jail felony offense of tampering with electronic monitoring device, and that's from April 30th of 2025. The indictment alleges that you were previously convicted of the state jail felony offense of theft, June 28th of 2010, and then you were also convicted of the state jail felony offense of theft on June 24th of 2013, and on that same date, the state jail felony offense of possession of a controlled substance. And how do you plead to that charge? And are those prior convictions true?
Yes, ma'am.
Did you enter your plea of guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Harmon is not competent?
There is none.
All right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find those prior convictions true, find sufficient evidence to find you guilty, and at this time find you guilty of tampering with electronic monitoring device, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. I will also hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right, good luck to you, ma'am. You can go back with the bailiff.
And just like that, another courtroom chapter comes to an end. A guilty plea, a 6-year sentence, and a reminder that every decision incident outside of courtroom carries lasting consequences. What do you think about this outcome? Was the sentence fair? Or should it have been different? Share your thoughts in the comments. And if you enjoy real courtroom breakdowns with expert analysis, don't forget to subscribe and turn on notifications so you never miss the next case.